In terms of business law, this particular next unit floor, there's really two distinct components to this unit. This unit looks at something called agency. And what agency is effectively, it is someone who represents you, or if you're a corporation, some person that represents you, the corporation. So you are an agent for. Okay, you're representing, you have a legal obligation or a legal right to represent that individual or that corporation. So agency law, as you can imagine, has a lot of implications for business and a lot of implications in terms of legal responsibilities and the like. So we're going to look at that. The second part of this deals with business structures. And business structures is important because what it is you set up a business. It could be a sole proprietorship, could be a partnership, or it could be a corporation. And all of those business structures have legal implications. So we're going to take a look at that. So that's what this business law, this is really like the law of doing business. This is what this particular unit is really focused on, is how do we cover off those things from a legal point of view and be aware of some of the legal niceties with regards to it. The resources for this part of the unit, for the particular textbook that's cited in this course, it's chapters 15, 16, and 17. But if you have another law textbook, introductory law textbook, because as I said many times in this course, every one of these introductory law textbooks cover exactly the same topics. So it's just a matter of finding the chapters that relate to the material. And the material, you will see the terminologies on them are exactly the same in every single course. So agency, for example, is usually a chapter in a law textbook, as is business structures. First part deals with this issue of agency. And in this unit, we're going to explain the roles and limitations placed on agents. We're going to look at the liability of what we call principals, which is the you or the corporation that hires an agent. So the principal is considered the individual that is being represented or the corporation that is being represented. Okay, so we use the word principals there. And the agent then is the person who represents the principal and has the power, certain legal authority to make contracts and the like for that principal. And we're going to describe this thing called a fiduciary duty. Fiduciary duty is the obligation of the agent or the obligation of the principal to the other. So the agent's responsibilities to the principal and the principal's responsibility to the agent to act in their best behalf. So an agent, by definition, is a person who represents another, and the other is called a principal, in dealing with a third party. So we've got this triangle set up where you have the corporation or the individual, you have an agent who represents that corporation or agent, and you have someone that they're contracting with. So that person can be an employee, which gives that person certain legal rights, and we've talked about this concept of vicarious liability already in this course. Or it could be an independent contractor. So for example, if you think about insurance agents represent an insurance company, and they act on their behalf, and they contract insurance policies on behalf of the insurance companies. But they are not employees of insurance companies. They're what's called an independent contractor. We're going to look at this concept of employee versus independent contractor when we move into, we're going to look at it more fully when we move into the employment unit. And effectively, what the agent's job is really, whether it be an employee or an independent contractor, the job of the agent is to enter into contracts on behalf of one another. So they're going to basically, an agent is responsible for writing contracts that's going to bind the principal to something. So it could include services such as filing documents or negotiation of a contract. Could be any number of things. In terms of creation of an agency is created when a principal grants authority to the agent to act on his or her behalf, usually by contract. So what we have is, in the case of employment, we have an employment contract, for example, where the principal says to the agent, Here are your rights and obligations and your duties. Okay, here are the things that you're going to do for me. You can set me up in contracts, you can sell products I own, you know, these sorts of things. It could be created what's called gratuitously, meaning that there's no real formal contract, but the actions of the agent and the actions of the principal in terms of, okay, the agent goes out and sets up a contract for the principal hasn't granted them authority to do that, but the principal agrees that, yeah, this is in the best interest, I'll carry through with it. That's what we mean by gratuitously, meaning that there's no hard rules say that he should have done that, but the principal agrees with it. And it could also be inferred by the conduct of the parties. If everyone agrees and carries through with it, we could have what's called an agency agreement. The problems with agency, or the challenges from a legal point of view with agency, is we run into this issue of authority. How much authority does the agent have to bind the principal in contract? So let's say, for example, let's go back to clearing snow again, okay? So I clear your snow. We have a contract for $10. I will clear your snow, okay? Now, I'm just so busy that I don't handle the dealing with you directly. I have a person who does that for me, an office person, okay? So you phone my office person, you say, well, I'd like Paul to come and clear my driveway for $10, and that person says, okay, yeah, we'll get Paul to do that. So effectively, you and I haven't discussed it. You and I haven't talked about it. You and I have not had a direct contract. There's nothing on the go, but you've spoken to my representative who has said, yeah, Paul will do that for $10. So Paul has basically agreed to the contract, not through Paul, but by some other third person. That third person then will be called the agent who is acting on my behalf. Now, the thing is, from my perspective, I am employing that individual, okay? I'm going to employ that individual. And I will say to that individual, okay, here's what I want you to do. I want you to take phone calls from people when they call in and they want their snow plowed. I want you to take their names, make them aware how much it's going to cost, and you tell them, yes, I will clear their driveway. So effectively, what I've said to that person in the office is, you can make contracts on my behalf. That's effectively what I've said. You know, the price is there, the time is there, all of the components that would be in a normal contract. However, I'm not having anything to do with it directly. I'm getting that person to do that. So if I said to that person in the office, that's what I want you to do, I have more or less given that person authority to contract on my behalf. And I have clearly indicated that if someone calls in for snow clearing, that is what their job is. So they have what's called expressed authority to contract on my behalf. So you call up, Paul, come plow my driveway, $10. Yep, okay, Paul will do that tomorrow. Great. There's the contract in place. The person that I put in the office doing that has set up the contract for me. And if I don't come and plow your driveway, you can sue me because I did not live up to the contract. And I can't argue that I didn't have anything to do with the contract because I had a person, an agent representing me, who set up the contract. So I'm still obliged to complete the contract. Let's take it, for example, a step further. Instead of plowing your driveway now, you call up that person and you say, well, I want Paul to dig a ditch for me. And I need the ditch to be 100 feet long and 6 feet deep and da-da-da-da-da. And that person on the other end of the phone, my agent, we'll call him, says, yeah, for $1,000, Paul will do that. Okay, great. Now, here is the problem. The problem is, in my mind, I have said to that person behind the desk, if someone calls for snow clearing, here's what you do. You say to them what the price of it is, you schedule the time, and I will go do it. I did not tell that person that if someone calls up to dig ditches, that we can set up a contract with them. I have not given that person the authority to sign contracts on my behalf for digging ditches. So there's a distinct difference, okay? I have in my mind, as the employer, I have clearly indicated that's for snow clearing. That person has gone and bound me for beyond snow clearing. Now, there's a couple of things I could do. I could say, no, I'm not going to do that. And that could create some problems for me, because that person, if you're the one that called in, and spoke to that person and said, I want the ditch dug, and that person said, yep, Paul will do that for $1,000. As far as you're concerned, in your mind, that person has bound me to dig a hole for you for $1,000. In my mind, as the employer of that person, I do not have the means, nor have I told the person on the desk that I will do that type of work. So I'm in a little bit of a pickle, because you have made an agreement with me to dig a hole that's $1,000 for work, and I'm thinking I don't want to do that. So as far as we're concerned here, the authority of the individual who is binding me to that contract has been overstepped. I have clearly indicated that person snow clearing only. That person has gone beyond snow clearing, so I'm not happy. Now, you don't know anything about that, nor should you. It's not your concern. You called up and you said, ditch digging, $1,000, got a deal. So I'm the one with the problem. And really, it is my problem, because I need to clearly say to that person, here are the confines of the work. Now, the trick is let's say, for example, that is not the first time that's happened. And let's say it's happened 10 times before, that type of thing, where it's a non-snow clearing related bit of work, and I've gone ahead and done it. Could I argue that that person on the front desk has outstripped that person's authority? No, I can't, because I have given that person what's called implied authority to contract me to go beyond snow clearing by the very fact of my actions. My actions are that I have done work before that is beyond the scope of snow clearing. So my implied authority to that person has stretched. So even though I haven't specifically said to that person, I only do snow clearing, even though I haven't said to that person I will do more than snow clearing, my actions have indicated, yes, I will do more, and that they can contract me to do more. So as an employer, I have to be very, very careful to ensure that I clearly indicate to that individual what the limits of their authority is, because I will end up in a little bit of a pickle if I say to that person, no, I'm not going to dig a ditch, because I don't do that, and that person false bounded me. I'm going to be because the implied authority has been given. We went to court. I said, no, I'm not going to do it, refused, and you sued. Then there could be a bit of a problem. Now, we also have this term, apparent authority. From talking to one of your relatives who say had work done by me before, that I dug their ditch, right? So you think then that, I do this type of work, and that person that was on the phone never questioned whether I do that type of work. So as far from your perspective, they have what's called apparent authority. So the principal does something to lead the third party to think that the agent has authority. In the past, I've allowed that person to go make contracts for me. That's happened. Here we go. That's what's called apparent authority. So we have to be clear on the three types of authority. We got expressed authority, which is officially what I've told my employees they can do, what they can contract to. That's what that's the bounds of the limits of the employee's responsibilities are defined by me, the employer. If that got stretched, and I agreed to do the things without any concern, I didn't speak to the person to say anything, then what we have is a bounding that is beyond the bounds set in the express authority. The bounds go on to what's called an implied authority. Let me just go out. Oh, go out to here. So we've got this expressed authority is, let me get my little thing here. The expressed authority is what I've officially told the person they can do. The implied authority is, well, I've kind of done what that person has bounded me to do. And the apparent authority is from the respect of the buyer or the person who comes looking. Apparently, that person here in the office can say that Paul does this type of work, and apparently, as far as you're concerned, I do that type of work. And so we see the bounds being stretched in each of those. So the expressed is what I say, implied is what I do, apparent is what you think. So this is the authority, and beyond that, there is what's called no authority to go on. So we should be familiar with the various three types of authority. Now, there's a legal term called estoppel, which prevents an employer from denying someone has authority. And this is where we get into, I say, well, that person contracted me to do the ditch digging. I never gave that person the authority to do that, so I don't want to have to do this. Well, the court's going to say, well, all your actions in the past, Paul, you've done it before, all your actions in the past led that person to believe that they did have authority. So estoppel basically prevents the employer from denying someone has authority. And where the principal does something to lead the third party to be reasonable to believe that the agent has authority to act, the principal cannot later deny such authority. So, if my actions in the past, as verbalized by other clients, say that I do this type of work, and that the agent has booked people to get the work done before, all things pointed to the fact that I do that type of work and that I would contract for that type of work. And that is exactly what the court is going to say you do, buddy, because all indications are that you do that sort of thing. We also bring in this concept of ratification. So where agent exceeds both actual and apparent authority, the principal is not bound but may still go ahead, ratify the agreement. So let's say it's clear that the agent exceeded both the actual and apparent authority. So just go back to this one here. The actual authority is what I told that person I would do. The implied authority is what I have done, and the apparent is what you as the buyer perceived I do. So if the agent went beyond this boundary, okay, with beyond this boundary, so I started off with snow clearing, now I've moved to ditch digging, and now I'm going to building buildings, okay? So let's assume that the agent has bound me to build a building. So I'd clear the land, dig the ditch, and build a building. Well, I'm not into the building business. One thing that I can do is, I can argue that, no, that's beyond the extent of what I do. And the agent had no authority to bound me on building houses. No one's ever seen me build houses before. I haven't done it before. Great. On the other hand, the other option is I could do what's called ratify, which is say, okay, I'll build a house too. So I may go and build a house and say, yes, I will build a house. So I may ratify intentionally by expressly ratifying. In other words, I say to you, yes, I will dig the ditch and build a house. Or I may ratify inadvertently by the principal taking some benefit under agreement. So you paid me $10,000. I took the $10,000 knowing full well that it involved building the house. I can't, I've taken the benefit of it, so I can't turn grant retroactive authority to the agent who bound me on this. The very fact that this is the challenge. I could go ahead and build a house and do the ditch. But effectively, what I've done is I've said to the agent, well, you do have authority to do that because my actions prove that you have done it. There are some restrictions on the ratification. It must have been possible to enter into a contract at the time of ratification. So I was of sound mind. All of the components that we looked at in order to enter into a contract, I must have there. And it must be possible to enter into a contract at the time the agent purported to act. Okay. So again, all of the conditions had to be right in order to allow this contract to go through when the agent agreed for me to do it. Maybe two of those times are the same. I must ratify within a reasonable time after the agent's unauthorized conduct. So I have to do the deal shortly after. Which kind of brings us to this whole issue of vicarious liability. And again, this is a rehash. We've talked about vicarious liability under contracts. Vicarious liability has to do with the liability that occurs to an employer by the actions of his or her employee in the course of their duties. So when one person is held responsible for the torts committed by another. So in this particular case, for example, the employee went and contracted me to do something I don't do. So basically, they have agreed to a contract that I build houses. I don't really build houses, but the fact of the matter is that person has bound me to it, and that person is not the one that's held responsible from the point of view of the contract. I'm the one held responsible. So both the principal and the agent may be held responsible in the case. Where the agent is employee, there will be vicarious liability if the employee acting within the scope of employment. Now the question is this within the scope of employment? Well, I've got an agent there that sets up contracts for me for work. That seems like it's within the scope of the employment. Now, if the agent is an independent contractor as opposed to an employee, then vicarious liability still applies, but maybe not as much. There are some restrictions on it. And the principal is really only liable if the tort causing injury took place during the actual exercise of the authority granted. So it's got to be in the workspace of what's happening. And sometimes it's just usually restricted to fraud and negligent misstatement. So, Paul builds houses all the time. That could be argued as a negligent misstatement. If agent passes information on innocently, the only principal who gave information is liable. So only the principal who gave the information is liable. And obviously statutes, which we've talked about there, that come in and plug holes in contracts, there could be something in statute that would say that I am liable as the employer on things. So statute may impose liability on owner of a vehicle when another has been given permission to use the motor vehicle, either expressly or implied. So if you got someone going out, an employee, and they go use the company vehicle, they do something to damage, someone gets hurt, that sort of thing, then effectively the liability goes back on the employer. So you have to understand that from a legal point of view, the agent would go to the lawyer and say, who's responsible here? If I've made a contract as an agent, I've made a contract on behalf of my principal, who's responsible? So we got to think now, well, if you're an employee of the person who is the principal, are you operating within the bounds of your authority? And if the answer is yes, then more than likely the principal will be the guilty party for any of the claims that would be laid against the agent. So, if I'm in the construction business or in this, I've grown into the construction business. I started in the snow clearing business. I've grown into the construction business. and the agent has bound me to do some work, and something goes wrong, something happens, I get sued. Well, I'm going to say, no, it's the agent's fault. The agent didn't. No, that's not the way it works. The third party usually has no claim against the agent. The agent was just, as long as the agent was just doing their job. Now, that's not to say, okay, so let's assume the agent, the person I hired to set up contract, has set up contract with you to dig a ditch, build a house, and plow snow. Something goes wrong, you sue. Well, I'm going to say I have nothing to do with you because my agent set it up. Sue them. No, that's not the way it works. The agent is working on my behalf, and the thing is, the agent is not liable, but I am, as long as they're working within their duties. So if the agent exceeds the authority, the third party can sue the agent for claiming authority not possessed. So effectively, the agent went beyond their authority. Now, this would have to be their granted authority, their implied authority. It has to go beyond that. So if the agent says that bound me, for example, as the employer, to build a house, I've never done it before, I could say that agent has really bound me to do something I don't do. And really, if the agent has exceeded the authority, the third party can sue the agent for misleading. So I'm not going to suffer for my agent's misconduct there. So those are some interesting things there. As a buyer, you're going and contracting for this work. You may not even know I exist because you're only dealing with the person on the other end of the phone. That person is an agent on my behalf, and you haven't talked to me at all. So in the case of an undisclosed principal, when you don't know about me at all, when the agent does not disclose he or she is acting as an agent or refuses to disclose who the principal is, the third party may sue the agent. So, you know, if you made a deal with the agent, you don't know I exist, you don't know I'm the one behind it. Obviously, the agent's job is to make sure that I'm the one doing the work, and you know it. If they don't do that, it could be a problem. When identity of the principal is learned, a binding choice must be made as to which party to sue. So if you find out that I'm the one behind it, you got to choose. I'm either going to sue the agent who went beyond their authority, or you're going to sue Paul. Most likely you're going to sue Paul because that's the one that would certainly be found guilty for sure. If the contract is for an undisclosed principal, no binding if identity of undisclosed important. Identity of the undisclosed principal is important. So you've made a deal with Paul's company through Paul's agent to plow snow. Is it important that you know who I am? I think I would argue no, it's not. It's plowing snow. It's pretty straightforward. If it's building houses, maybe it's important to know who the actual builder is. For certain other types of contracts, it might be absolutely critical to know who the builder is. For example, they have to meet health and safety requirements, that sort of thing. So it depends on the situation if it would bound or not. So what we got in this principal-agency relationship are a couple of things we need to be aware of. There is authority. We need to make sure the authority is clear, and we need to make sure the authority is clear to the people who are buying the products from us. If we run into problem, it's because we were not clear on how much authority that agent had. That creates problems, and employers should be aware of that. And they should do everything possible to make sure that their agents have a discrete amount of authority to bind them to contracts. The other thing that we have to look at here is this, what's called a fiduciary duty. We've talked about this, I mentioned it before, that, you know, a fiduciary duty, when you work for someone as an agent, let's assume that you're an agent. Now look at it from the agent's point of view. You have an obligation to make sure that you do everything in your power to fairly and accurately and do your best to represent the principal. That's your job after all. You've been hired to represent that company or represent that individual, and you're going to work in their best interest. By definition, that's what we call a fiduciary duty. So what does a fiduciary duty mean in terms of a law? And in terms of the law, well, it means you must operate in utmost good faith. You can't take personal advantage of business opportunity. You must disclose all conflicts of interest. You must make full disclosure of all information, and you must act only for one side in a transaction. Now, this is an important one for anyone that represents. Lawyers, for example, are really agents. If I go hire a lawyer, you sue me, and I go hire a lawyer to act on my behalf, then we've got an agent relationship created with the lawyer. So the lawyer has to act in utmost good faith towards me, cannot take any more personal advantage of the business opportunity other than to get paid. But, they can't get something in it for themselves other than the payment or fee. They must disclose any conflict of interest, if they're working for the other side or if they're lawyers for the other side as well. They must take full disclosure of all information. This is typical so that nothing is, oh, I wasn't aware of that type of thing to anyone. And they must act for one side in the transaction. So they can't walk both sides of the fence. So, and they can't make a profit at the expense of the principal. So, that, again, a lot of this is sensical. You're not going to have an agent who's making money on ripping off the principal. Has a duty of accounting, cannot take secret commissions. It would be criminal to pay someone a secret commission. So say, for example, if you can get that deal done with me, you as the buyer would say, I'll give the agent a special bonus, a turkey or money. Can't do that. Has a duty to act competently. So, if there's a job to be done, that job has to be done properly, such as my lawyer would act competently with legal matters and the like. And they can't delegate responsibilities except where it's based on certain industry practices. Now, in the case of lawyers, when I'm buying a house, for example, what the lawyers often do is they delegate responsibilities. So if I'm speaking to a lawyer, that lawyer is going to get someone in the firm to search out the deed and check to ensure there's no encumbrances and these sorts of things. That's just normal for that type of industry. It may not be normal for others, so it really depends on the industry. The authority, if the agent is working for me and the agent goes and binds me for contracts and I run into some problems, well, I got some options as an employer. So if I grant the agent working for me the authority to contract me, that authority to contract with me ends when that person quits, leaves, whatever. So the job is finished. So let's say, for example, I hire someone on to represent me. They quit. They no longer represent me. Now that creates a little bit of a problem for me because I know that, but do you know that? Do you know they're no longer working for me? There is the problem with agents. So let's say, for example, you hire someone, they're working for you, you give them authority to do a bunch of things on your behalf, they leave your work, they no longer have the formal authority to do anything on your behalf. However, the buyers and the people that they dealt with do not know that. And that creates a bit of a problem for you. So we got to be careful on making sure that the actual authority of our agents is clearly communicated to our buyers. So, we need to know if someone leaves their work. So oftentimes what you used to see in the paper, you don't have papers anymore, but you used to see that Paul Tilley no longer works for XYZ firm. Sometimes you used to see an announcement in the paper for that because Paul Tilley was an agent for them, and what the company did in order to help ensure that they didn't run any problems is they made people aware that that person no longer had authority to act as an agent for them. We could also change the agent's instructions. Okay, I am just limiting you now to sell contracts for snow clearing only. Do not do anything else besides snow clearing. There's different instructions, right? So we're clearly defining what the authority is and limiting it. You know, and the employment relationship could have changed or ended. That could change that. Actual authority also ends when the project becomes illegal or the principal dies, goes bankrupt, or becomes insane. We've seen that before. That's a typical situation whenever the ability of the person to contract has disappeared, the contract disappears. And the last thing, in terms of ending the agency relationship, if the issue of apparent authority remains, it's best to avoid apparent authority from the start. In other words, make your employees clear on what they can do and what they can't do. Where apparent authority exists, principal must notify customers and suppliers who deal with the agent when the agent relationship ends. And I've just mentioned that. You have to make people aware. So the power of attorney that continues after principal becomes mentally incapacitated is now possible. In other words, if I hire a lawyer to act on my behalf, and then I become insane, I can still that lawyer can still act on my behalf. Okay, so that's a very quick overview of that first part of the agent's relationship. That's as far as I was going to go this morning. Are there any questions? We'll look at some examples of this in the next class just to kind of give it a little more clarity. This is the overall introduction. So we'll continue with this next class.